Good morning, good afternoon, good evening, depending on where you are. Welcome to today's session of the IISD webinar series on investment law and policy. My name is Martin Brauch, and I'm an international law advisor at IISD. I will be your moderator today. This webinar series is part of IISD's work with governments and civil society on legal and policy tools designed to leverage investment for sustainable development. I'd just like to take this moment to invite you to visit our website to learn more about our work. Also on our website, you will find background documents prepared for previous sessions of this webinar series, as well as recordings of those webinars. And also on our website, iisd.org/ITN, you will find investment treaty news. ITN is our online journal on investment law and policy. It includes short analysis pieces on key investment law themes. It also includes news reporting and case summaries of investment arbitration awards. Our archives go back 16 years to 2003. You can access past issues, and you can subscribe to receive future issues in your email inbox, both free of charge. Our webinar today will focus on developments in investment negotiations, dispute settlement, and reform from a practitioner's perspective. Currently, there are over 3,000 investment treaties and over 900 known investor-state arbitration, or ISDS, cases. Several states and other stakeholders have flagged problems in the investment regime and are now calling for a much-needed reform of the investment regime. Innovative investment treaties and treaty models are moving away from the investor protection paradigm of older generation treaties. Also, multilateral deliberations on ISDS reform are underway at the UN Commission on International Trade Law, UNCITRAL. There's also a process ongoing at the International Center for Settlement of Investment Disputes, ICSID, to amend the ICSID arbitration rules. As these reform initiatives and debates continue, countries will need to incorporate lessons learned and build on the experience and developments in investment arbitration. And our webinar today is designed to give investment negotiators an insight into the perspective of an arbitration practitioner. Our speaker today is George Cahill. He's chairman at Curtis, an international law firm headquartered in New York. He has represented many states in investment arbitrations and has long been a critic of the investment regime. He has appeared as a speaker on this theme at various seminars and conferences, including the 12th Annual Forum of Developing Country Investment Negotiators. This forum was hosted by IISD, as well as the South Center and the Government of Colombia in Cartagena, Colombia, earlier this year. So we will begin with a 30-minute video recording of George Cahill's presentation at our annual forum, where he will provide his perspective as a practitioner on how investment arbitration has evolved. After the video, George Cahill will be answering questions from participants. Don't be shy to submit your questions in writing at any point during his presentation. You can type them either into the webinar chat facility or into the dedicated Q&A facility on Zoom. We will have about 30 minutes for Q&A after the video is screened. And we will aim at wrapping up the webinar in about 1 hour and 15 minutes from now. Welcome again to everyone. Thank you for participating today. And let's now hear from George Cahill.
Good morning, everyone. First, let me say that it is a privilege for me to address you today on a topic of great importance to the states, investor-state arbitration. And when I say states, I don't discriminate. I mean states large and small, rich and poor, east and west, north and south, states of all political persuasions. Virtually all of them have been participants in this system. They came into it thinking that they were beneficiaries, but now many are beginning to view themselves as victims. As some of you may know, I've had occasions previously to speak on this subject, but this is a special occasion for me because the conference is for states, not for investors. Traditionally, conferences on ISDS have had a decidedly investor orientation, concentrating on how to make the system more effective for investors and developing new theories for expanding the scope of investor protection, all at the expense of states. I would say those were the predominant themes of the first quarter of the century of ISDS. Now, ironically, states were not mere bystanders in this process. They were actually active participants, just as they were in creating the treaties, drafting, negotiating, and bringing us to this day when we have a web of about 3,500 investment treaties, a large number of which were undoubtedly entered into with little understanding of the provisions being negotiated or the implications for state sovereignty. Some of you may be familiar with the characterization of such treaties by one former Attorney General who stated that they were signed, and I'm quoting now, without any consideration, without any negotiation or consideration of the consequences. He also said that most of the treaties were signed because a dignitary was visiting a foreign country or vice versa, and the two governments couldn't think of any other document to sign. And he also said that a BIT provides a good photo opportunity. Now, unfortunately, these photo ops have turned into what I call weapons of legal destruction. The underlying philosophy of these treaties was that they were inherently good, even necessary to promote foreign investment, and that anything that was good for foreign investment had to be good for the country, no matter what the price. This was particularly true in the 1990s. In that decade, not only were many investment treaties concluded without serious analysis of the consequences, but many long-term concessions involving the bulk of the nation's wealth were granted to private parties on extremely favorable terms, or should I say unfavorable terms for the states concerned. Again, many states felt that they had no choice but to enter into those unfavorable deals in order to attract foreign investment. And they were comforted by the notion that anything private would eventually be in the public interest. So there was no need to drive hard bargains with private investors. Not surprisingly, this state of affairs was a recipe for disaster. Just to take one example, and not a small one considering what was at stake, look at what happened in the oil industry. The issue, the 1990s was a period of low oil prices, as you may remember. The price averaged in the teens throughout the decade. That also happened to be the decade in which privatization was the prevailing ideology, particularly after the collapse of the Soviet Union. The results were long-term contracts under terms and conditions that were in fact unsustainable in the long term. You may recall that the price of oil averaged around $12 per barrel for all of 1998. The entire year, the average was about $12 per barrel. But by 2008, one decade later, the average for the year had increased eightfold to around $100 per barrel, and it reached a high of approximately $150 per barrel in the middle of 2008. Now, what do you expect the reaction of the state to be when it wakes up one day and realizes that its natural resources have been committed for the next 30 years to foreign companies reaping windfall profits and taking them out of the country? This is not a matter of ideology, right or left. It is a matter of common sense. Whether you are a believer in state-run economies or a champion of privatization, the one thing everyone should be able to agree on is that giving away a nation's wealth for nothing, or almost nothing, is not a good idea. But that's what happened in too many cases in the 1990s. Now let's bring it back to ISDS. In the past, when these giveaways occurred, the mistakes could easily be rectified because states enjoyed privileges that protected them from litigation. Under the doctrine of sovereign immunity, a state enjoyed immunity from suit and its assets enjoyed immunity from execution. But commencing in the 1950s and then accelerating in the 1970s, that immunity was watered down under what is called the restrictive theory of sovereign immunity, so that the state could be sued in respect of its commercial activity, but it still enjoyed immunity in respect of sovereign activity, referred to as jure imperii. It wasn't until the proliferation of investment treaties that claims against states could routinely be brought even when they acted in the exercise of sovereign powers. In fact, the point of investment treaties is precisely to allow private parties to bring cases against states when they act in a sovereign rather than a commercial capacity. As a consequence, the legal, as opposed to the economic, balance of power in the investor-state relationship, which had been tilted heavily in favor of states, began to shift to the side of the investors. And the process has continued ever since. The investment treaties not only set forth substantive obligations of states, but they also established a dispute settlement mechanism that virtually guaranteed that those substantive obligations would be developed and eventually expanded beyond anything contemplated by the states that signed those treaties. The problem states face in ISDS is both substantive and procedural. Taking the latter first, ISDS lacks the basic attributes of a legal system, including a body of law that commands respect, judges to apply it, and checks and balances to prevent and, where necessary, correct errors. That's why I called it the wild, wild west of international practice. The ad hoc tribunals of ISDS usually have 3 arbitrators, one appointed by each side and the third by agreement of either the 2 arbitrators or the 2 parties, or, failing agreement, by one of the arbitral institutions, such as ICSID, the PCA, ICC, SCC. Now, some of these arbitrators are extraordinary international lawyers with long and distinguished careers. But many others are not, and there are no real requirements in terms of credentials or training. There are also few tangible requirements in terms of conflicts of interest. Arbitral institutions do have their own rules requiring independence and impartiality, but the reality is that these terms have not been applied as strictly as they would be in a mature national legal system. But I think the most important procedural point is the fact that arbitrators depend upon further appointments for their income, at least their income as arbitrators. In ISDS, this feature works against the interests of states. A very large percentage of awards in investor-state arbitration are published, and they are studied not only in academic institutions, but by investors all over the world who are potential claimants in arbitration. Obviously, there is an infinite number of such claimants and a finite number of state respondents. Whether consciously or subconsciously, an arbitrator dependent upon future appointments may be impacted by the understanding that rendering a legal decision against an investor may be detrimental to his or her own personal interest. By the same token, the arbitrator will understand that rendering an opinion with a decidedly investor leaning will enhance the chances of further appointments. That is not a matter that enters into the thinking, for example, of a federal judge in the United States who enjoys a lifetime appointment and has no concern whatsoever about maintaining his or her caseload. Quite the contrary, most federal judges would be far too happy to give up cases and lighten their caseload. The selection of the tribunal is one of the most important events in any case. Indeed, it's no exaggeration to say that an experienced practitioner can predict the outcome simply by looking at the composition of the tribunal. In far too many cases, that is more important than the legal principles or the facts at issue. Again, that's not the case in a mature legal system where the judge's main interest is in applying the law as it stands, knowing full well that a departure from established legal principles is likely to lead to reversal on appeal and potential embarrassment to the judge. Unfortunately, this state of affairs makes it difficult for states to have confidence in ISDS. The problem they face when it comes time to appoint an arbitrator is that the pool of acceptable candidates is relatively limited. By contrast, investors have little difficulty finding candidates who share their outlook on the law and are willing to promote it in their capacity as arbitrators. And when it comes time to select the all-important third arbitrator, states can only hope that the selection will be relatively neutral, as opposed to decidedly pro-investor. On the substance, there can be no doubt that states have been victims of expansive interpretations of amorphous treaty provisions such as fair and equitable treatment. That is a standard provision designed to incorporate the minimum standard of treatment under customary international law. But it has been interpreted in some cases to encompass far looser provisions, standards, such as legitimate expectations, which can easily morph into any governmental action that disappoints an investor. In virtually every case involving FET, the investor argues for such broad standards, rejecting the notion that FET does no more than reflect the minimum standard of treatment. Or even worse, asserting that the broader standards adopted by some tribunals now reflect the minimum standard of treatment under customary international law, because customary international law has evolved to incorporate those standards. But a practice does not become or evolve into a rule of customary international law unless it is generally accepted by states out of a sense of obligation. And states all over the world have stated in no uncertain terms that these loose interpretations are erroneous. They don't accept these standards. So it could not have evolved into a rule of customary international law. For example, the three parties to NAFTA felt that they had to enter into an interpretation of their FET provision to make clear that it does not extend beyond the minimum standard of treatment. The model US and Canada BITs now explicitly confirm that point, and many of the new treaties that you see define FET to exclude legitimate expectations and define exactly what they mean by FET in the terms of the minimum standard of treatment. And one has to ask, how many times is it necessary for states to make that point before tribunals get the message and accept it? As I pointed out previously, all of this has a very negative impact on the development of public international law, something we should all lament. But this negative impact is magnified many times when one considers the sheer size of the typical claim in today's ISDS. Years ago, a $50 million claim would have been considered huge. But nowadays, you can add a zero to that number, and hard as it may be to believe, billion-dollar claims are commonplace. This is the era of the mega case. Of course, the Yukos case broke all records with a claim of over $100 billion, if you can believe that, and an award of over $50 billion. That was 20 times, in 2014, I think it was, that was 20 times the largest award in history up until that time. That's what I call really breaking a record. Now, you probably know that after 10 years of arbitration, the Yukos award was set aside by a court in the Netherlands, but that decision has been on appeal, and the whole world is waiting for the result. While the Yukos case is the largest, it is not the only multi-billion-dollar claim around. We've seen claims of 20 billion, 30, and more, which would have been inconceivable a short time ago. States facing ISDS claims have to pay as much or even greater attention to quantum issues as they do to jurisdiction and the merits. It is important not only to note the increase in the size of quantum claims, but to have a clear understanding of the tools used to create them. Claim exaggeration is not a new phenomenon. It happens everywhere and even has a name. It's called the anchoring strategy, where a claimant starts out with an outrageous demand in order to make a lower but still outrageous figure appear reasonable. Of course, to make this strategy work, claimants often count on the assistance of economic experts to dress up their figures with a professional analysis, which usually means a discounted cash flow analysis. DCF requires a projection of future cash flows over the life of the asset or project in question, including production, sales, prices, operating costs, capex, taxes, everything that goes into the cash flows that you need to arrive at a net present value. And at the end, you apply a discount rate to bring that cash flow back to the present value. With so many variables and so many assumptions, it is easy to see the potential for abuse. In fact, the World Bank guidelines on the treatment of foreign direct investment explicitly warn that, and I'm quoting now, particular caution should be observed in applying this method, referring to DCF, as experience shows that investors tend to greatly exaggerate their claims of compensation for lost future profits, unquote. That's the World Bank guidelines. In the words of one economic analyst, which I agree with, and I quote, "The DCF method has indeed been tainted by misapplication, and it has been used to justify valuations which reach beyond the fanciful to wonderland proportions," unquote. The difference in valuations resulting from different assumptions as to cash flows and discount rates can be hundreds of millions, if not billions of dollars. We've seen many cases illustrating this point. What this all means is that manifest errors resulting from the misapplication of basic legal principles are not just costly in terms of development of international law, but they are also costly in financial terms. When so much is at stake, even one mistake is too much. More and more states are coming to this conclusion. That's what happens when you get bitten. It's easy to support ISDS when there is no price to pay. But with each bad award, another state becomes skeptical of ISDS, realizing that its supposed benefits are grossly exaggerated and its costs can be exorbitant. We've seen heated debates on the subject in many countries, including some of the countries here, if not most. And this sometimes results in the denunciation of treaties, You can see, for example, the reaction in India, Indonesia, South Africa, Bolivia, Ecuador, and Venezuela. Traditionally, the US and Europe, capital exporters, have been champions of ISDS, largely to protect their multinationals investing in Latin America, Africa, and Asia. I can see a lot there in this one. But in recent years, we have seen a marked rise in anti-ISDS sentiment in Europe and the United States. Why? One good reason, I submit, would be that European countries in recent years have become the unlikely victims of ISDS, with dozens of claims brought against them. Spain alone has faced over 40 claims in just the last few years. It's easy to champion ISDS when you don't face claims and can gain points at home for supporting your corporations doing business abroad. It's not so easy when you are on the receiving end of dozens of claims challenging what you consider to be the legitimate exercise of your sovereign powers and seeking enormous sums in damages. The United States has long had an ambivalent attitude toward ISDS. On the one hand, the capital exporting multinationals have been a powerful force in promoting it. On the other, the US, particularly the Republicans, one might say, will not stand for subjecting American sovereignty to any international arbitral tribunal, or any international tribunal at all. This tension up until now has been resolved in favor of continuing support for ISDS, while reining in at the same time arbitral tribunals with more precise definitions of concepts such as FET and MFN, most favored nations. The US could afford to walk that line because, as it has proudly proclaimed, it has never lost a case. One can only imagine what Mr. Trump would do if the US actually did lose the case. And if it happened to be a $50 billion or $20 billion or even $10 billion case, what do you think would be more likely? Pay it and sing the praises of ISDS, or demand the immediate dismantling of the system? In any event, before that time, even before that time, the US attitude seems to be changing. During the recent NAFTA renegotiation, 230 professors signed an open letter to President Trump urging him, and I quote, to remove ISDS from NAFTA, as well as to leave it out of any future trade or investment pact, unquote. I don't know whether he was listening to them, I suspect not, but the negotiations did result in the elimination of the ISDS provisions with Canada and a curtailment of them with Mexico. It's actually Mexico that wanted to keep them, not the United States. Underlying the Trump administration's position appears to be some combination of a desire to discourage foreign investment, that is, American foreign investment abroad, and an anti-internationalism which refuses to acknowledge the authority of any international body, much less that of an ad hoc arbitral tribunal. I don't particularly share either of those sentiments, but it is hard to take issue with the anti-ISDS stance. That's because ISDS is a system so flawed and so dangerous that any move toward its dismantling is worthy of applause, even if the motivations are wrong. That brings us full circle. Remember at the outset I noted that traditionally most conferences on ISDS started from the premise of its inherent goodness, the main question being how to improve its efficiency for investors. The discussion on the conference circuit is more balanced today. because there is an increasing realization that the system is efficient and not serving the interests of the states who created it. This has led to cries for reform and the formation of UNCITRAL Working Group 3, whose mandate is to analyze whether the system is in need of reform, and if so, to recommend changes. These issues are now being taken seriously. But I have to say I'm still not very optimistic about the outcome of the process, and I remain concerned that the cure may be worse than the disease. The UNCITRAL Working Group excludes substance from its mandate, meaning that it is not supposed to address the recurring substantive issues that have caused problems in ISDS. The group is focusing only on procedural issues, such as the methods of formation of arbitral tribunals and the possibility of introducing an appellate mechanism. Those are indeed serious issues, but addressing them without addressing the underlying substantive issues runs the risk of institutionalizing the bad and paving the way for the worst. As they say, be careful what you wish for. Another problem I see with the working group is that even though there is more of an emphasis on the interests of states, there is still a tendency to view ISDS as a system with many stakeholders. Everybody's a stakeholder, of course, including the investors. As if all of them have the same vested interest in the system. This means that any proposed reform coming out of the working group is likely to reflect compromises that may well not fix the existing problems and create new ones. It's based on the premise that the existing system is good and needs only minor tinkering, is likely not to serve the interests of states. That is why I think states would be well advised to rethink their investment treaties and explore options for first terminating their ISDS provisions, or at least agreeing with their counterparties on the interpretation of other key provisions of their treaties, or terminating the treaties altogether if agreement cannot be reached. I think it would also be useful to set down basic principles on substantive issues that should command the support of large numbers of states. In that regard, it is not necessary to await consensus on a model investment agreement, or even on the precise wording of the model clauses dealing with individual issues. Substantive progress can be made incrementally. Statements of principle on recurring issues can be of assistance if large numbers of states adopt them. And as long as the endeavor is not too ambitious, it should not be that difficult to achieve broad consensus on at least some principles. That is just a matter of translating the positions that states almost uniformly are now taking in the arbitrations into positions outside of the arbitrations. For example, even if there are nuances in the positions of different states, it should not be that difficult to obtain broad support for at least the following general propositions. That absent express language to the contrary, the concept of FET is only meant to cover the minimum standard of treatment. That the content of the minimum standard is the prohibition of shocking and egregious conduct that falls so far short of minimum standards as to be readily apparent to any reasonable person. And that absent express language to the contrary, an MFN clause refers to nationality-based discriminatory treatment and does not allow the importation of either jurisdictional provisions or substantive standards from other treaties. In the meantime, again, to circle back one last time, it should be clear that the days of signing investment agreements because they are good photo ops should be over. I thank you for your attention. I'll be happy to take questions.
Thank you to George Cahill for the informative and insightful presentation today. To me, it is always interesting to hear the perspective from a private practitioner that is so lucid in the sense that the ISDS regime needs reform and that recognizes these cries for reform. It's particularly striking to me to hear a practitioner saying that any move towards the dismantling of this regime is welcome, given that this regime is so flawed, it's deficient, it doesn't serve the interests of states. But then again, of course, it's interesting also to hear George's concerns about the current reform discussions and the specific focus on procedural reforms, especially in the ancestral context. As we mentioned in advance of this webinar, George would be able to join us today and to reply to questions live. So again, thank you, George, for your live participation today and welcome. We will now move on to the Q&A session of the webinar. For those of you who have not asked a question and would like to do so, please type your question into the webinar chat facility on Zoom or into the Q&A facility. We have 2 questions already in the Q&A of our webinar platform, and I would be pleased to start with those. So starting with the first one, has there been any increase in incorporating the precautionary principle in bilateral investment treaties during recent negotiations? We'd be happy to hear your thoughts on this one, George.
Yes, thank you. I'm not quite sure what is meant by the precautionary principle, but I would say that there has been an increase in attention, as I said during the address, in attempts to define the expansive concepts of ISDS, most particularly, I would say, FET. You will see a tendency in many of the newer treaties to limit the scope of FET, particularly with respect to the concept of legitimate expectations. I would say about half of the new treaties indicate a very clear desire on the part of the negotiating states to do that. But then there's the other half where it's business as usual, and you can hardly tell any difference from the old treaties. As you know, there is many of the new treaties also pay lip service to the concept of an appellate mechanism or a review mechanism of some kind. But really that hasn't gotten off the ground despite all the efforts, especially of the European Commission. I don't see that gaining enough traction to become a reality. But that is obviously a burning issue in the negotiations now.
Thank you very much, George. We have a second question here that I'd like to move on to, and I think you may have quite a bit to share on this one. What can be done to limit the conflicts of interest that you pointed out, that you referred to in your presentation? Can an international investment court do away with it as being now discussed in the context of the EU and also now being brought also by the EU into the ancestral context?
Well, I'm not sure that anything can be done that would be effective in the context of the current system, which is why I've been calling for, I would not either a complete revamping or a dismantling of the system. It is true that an international court would go a long way towards solving the problem. But I'm worried about the cure being worse than the disease, as I said in my discussion in Cartagena, because the questions are how would this court be formed? Who would be the members of the court, and what rules would they be applying or administering? And I think until those questions are answered, I'm not sure that the benefits you get from the court are worth the potential disadvantages of actually going ahead and forming it until the core problems are solved. So under the system as it's currently constructed, I'm not sure that there's anything that can address the issue of conflicts, because of the conflict issue stems from the manner in which tribunals are formed. It's not that there are no rules on conflicts in international arbitration. There are rules. As a matter of fact, it's really hard to distinguish from a technical standpoint, the rules of conflict that apply to arbitrators from the rules that apply to a federal judge in the United States. The difference isn't in the rules, it's in the application of the rules. And it's also I think most importantly, and this is not necessarily a conflict issue, but it's a related issue. It's in how an arbitrator who makes a living as an arbitrator gets his or her appointments, which is of course fundamentally different from a standing court.
Thank you very much, George. We have another question now from Martin Masilela. He would like to ask you to He'd like to ask you, how can countries with a bad history of judicial interference deal with localizing ISDS? And I was just following up with him on this. By localizing, he means here the example of South Africa and Namibia that are trying to move away from international arbitration. South Africa setting up this system of mediation with foreign investors, and Namibia relying also on its domestic courts and its domestic laws. So what are your views on the challenges that these countries allegedly having a bad history of judicial interference have with localizing ISDS, moving away from international arbitration to more domestic-based systems, either of mediation or domestic arbitration or domestic courts?
Well, I think this is an important issue that came up. I remember in the conference in Cartagena. It's obviously a very, very difficult issue, and always used as the primary justification for ISDS in the first place, which is, if not ISDS, what else? Because if you want to attract foreign investment, you have to have confidence, or let's say the international investors, the foreign investors, have to have confidence in local remedies. And if they don't have confidence, they may not invest. That's always the tension. I'm not sure what can be done about that, but I would make a few comments. Number one, in my experience, the effect of an investment treaty in terms of the tangible effect in terms of attracting foreign investment is limited at best. And very often the type of investment that is attracted is not the kind of investment that a country should want. So I'm not sure that the answer is to have an investment treaty. And I think the disadvantages there tend to outweigh the advantages. I think we should also remember that investment treaties constitute standing, open-ended offers to arbitrate any investment dispute. A country seeking to attract investment doesn't have to do so through an investment treaty. It can always enter into individual arbitration agreements or tailored contracts with specific investors that it knows it wants to attract and that it knows it's getting the benefit from. So I don't see that problem as a valid excuse for entering into investment treaties. And I do think that the moves toward the establishment of regional organizations and regional methods of dispute resolution, including especially mediation, I think all that is very positive.
Thank you very much, George. I would like to play my moderator card here and pick up on a point that you just raised about the effect of investment treaties in terms of attracting foreign direct investment. And you mentioned that this effect is in fact limited. There's little evidence about it. There are studies published on this topic by several academics, including one published by the OECD, another one that we published also at IISD by a colleague, Jonathan Bonniccia, analyzing the impacts of investment treaties. And in addition to this limited effect of investment treaties in terms of attracting FDI, there's another economic issue here that is very relevant, which is scarcity of resources, right? Which states face in their budgets, and they have to dedicate their resources effectively for the public good. And there's this dilemma between, investing time and resources, human resources as well as economic resources, into negotiating new investment treaties, which, as you pointed out, have this limited effect in terms of attracting investment. And on the other hand, investing resources in defending the state in these international arbitrations that arise from those from arbitrations under those treaties. So my question is, how do you think states can better allocate those resources? Is it worth investing in the negotiation of bilateral investment treaties that have this limited impact on attracting investment and at the same time create this huge litigation risk for the state? Are these negotiations worth it?
Yes, well, I think I've made my position relatively clear on the utility of investment agreements for states in general. I do think that time should be spent in negotiations, but not in the negotiation of new treaties. I think time would be well spent in negotiating the termination of treaties, and especially the termination of ISDS provisions of treaties. And if that's not available, in the negotiation of interpretations of treaties that will at least make clear what the states meant by some of these concepts that are being abused by tribunals.
Thank you very much for this clarification. And so spending time in negotiations, not of treaties, but of termination, moving away from the system. And I think this is a nice segue to the two other questions that have been posed here in the Q&A. I think they can somewhat, I think I'm going to try to lump them together here. So José Shinjamba asks, could you explain what kind of substantive and procedural issues must be considered in reforming ISDS? So this is the reform end to deal with the existing system. And then Oladapo Fabusui, I'm sorry if I'm not pronouncing your name correctly. He thanks you for your presentation and asks what alternatives would there be to ISDS if it is to be dismantled?
Mm-hmm. Well, as I'm sure all of you know, there are a lot of alternatives on the table being discussed right now, especially in UNCITRAL Working Group 3, most of which consists of the formation of some sort of international court of investment arbitration. It's not clear exactly what that court would look like, whether it's the International Court of Justice or a series of regional courts, whether those regional courts would eventually be subject to appeal to one international court. I see that as very, very complex and frankly a little bit unrealistic. I could be proven wrong, of course. Sometime in the next few years, it's possible that consensus will develop on that kind of alternative. But I tend more towards the other end, which is reminding people that there was a world of international law before ISDS. ISDS is only basically about 25, 30 years old. And there's a long history of public international law and dispute settlement before ISDS. And it was perhaps unsatisfactory. There were a lot of issues with it. But frankly, given where we are today, I prefer the old system. And that's why my view has been for the last few years, having been a participant in this system, that maybe the best thing to do is to try to go back to square one and then build something that makes sense from there. Trying to build a new system on top of the existing one is like building another floor on a house with a very weak foundation. And that's what troubles me. And that's what I mean when I say that the cure may be worse than the disease.
Thank you very much, George, for these insights. I would like to ask another question also posed by our attendee, Oladapo Fabusui. He asks, or he mentions you also referred to stakeholders. Who are those you will refer to as legitimate stakeholders of the international investment law regime, is his question.
Yes, well, I take a very simplistic view on that point. I believe that the stakeholders are the states. I would say in ISDS conferences generally, and in UNCITRAL working groups, in the past, these conferences, which are supposed to be among state representatives, if you look and see the people participating in the conferences appointed by the states themselves, they basically largely represent the private sector. So I'm not sure what to expect when you have a conference with the private sector being at least as important a stakeholder as the states. Now, I have to say that's not true from what I can observe of Working Group 3. For the first time, I think there is a much greater emphasis on state representatives rather than, as a matter of fact, I think there are relatively few private practitioners that are even allowed into the Working Group 3 meetings. And that just shows you the evolution of thought among states. As I said in the presentation, every time a state gets bitten by an award, it becomes a convert and becomes more sensitized to the risks of ISDS. And most recently, you see that in Europe. And so that's why there is this shift. But the premise of UNCITRAL Working Group 3 is still to reform the existing system, not to address questions of substance, to deal exclusively with questions of form and procedure, about which I am very skeptical. Because I'm concerned that it runs the risk of institutionalizing, as I said in the presentation, institutionalizing the bad and making life even more difficult going forward.
Thank you very much, George. I think an interesting follow-up to this, while participants are thinking of other questions, would be with respect to stakeholders. You mentioned that Working Group 3 at UNCITRAL is trying to be more inclusive, trying to move away from private parties sitting behind the state delegates' desks. I would like to ask you, and you also referred to traditional international law where only states were actors. But as you know, IISD is one civil society organization, and we have among us today several attendees who are also from academia and civil society organizations who are following the UNCITRAL and other reform processes and willing to engage in those processes. I would like to ask you whether you have any opinion on the importance, on the role of civil society, of academics, of practitioners as well as private sector, of investors, of domestic investors. How do you see the openness of these reform processes to engagement from other stakeholders? How do you see this playing out in the current reform processes?
Well, I think that's a very good question. I think that these new actors, if you will, in this area, make a very positive contribution. In fact, one of my regrets is that people from academia have really shied away from participating in the process. There is a lot of criticism, and lots of books and articles are written by them, but always from the outside. For example, just to be concrete from my perspective as a practitioner, I mentioned in the discussion the relatively limited pool of arbitrators that I would consider to be people who have a strong knowledge of public international law and do not have a pro-investor bias, let's say. And a lot of these people are in academia and they do not want to participate in the system as arbitrators. And I think that's unfortunate because it seeds the ground to what is largely a pro-investor group among let's say the arbitration community and the pool of arbitrators. So yes, I think the participation of these of academia and institutes like yours is very positive and provides let's say some of those missing checks and balances. But unfortunately, it's not enough in terms of the actual, from a practitioner's standpoint and what goes on inside the arbitrations. Unfortunately, it's not enough.
Thank you very much, George. I think this is also an encouragement for the attendees among us here that are also willing to engage, and maybe even some of the academics. We have a new question, but before that, I would like to again encourage attendees to type in their questions. We still have some 15-20 minutes with George, so let's seize this opportunity to follow up on his presentation and get his view on the issues that you have been thinking about in this reform process in ISDS. So Barjab Verbeek asks or says, thank you for your presentation, Mr. Cahill. Could you share some insight based on your experience as arbitrator into how arbitral tribunals generally deal with other international law areas, such as human rights, environmental law, corporate social responsibility, in the context of investor-state arbitration cases? Would it be desirable or would it be feasible to incorporate stronger references to these other areas of international law into bilateral investment treaties? Is this desirable and feasible? Or are these not the adequate instruments, BITs, to do so?
Well, I think first I have to make clear that as a matter of policy, I do not serve as an arbitrator. This is one of those conflict issues, let's say, which you do have in international arbitration that you don't have in any mature national legal system. And that is, I don't believe that in investor-state arbitration, as opposed to private commercial arbitration, where it doesn't really make that much difference. In investor-state arbitration, where you have these grand issues of public international law, and you really need to take a position one way or another, I think there's an inherent conflict in acting as a counsel, which I do regularly, and arbitrator at the same time. So I do not, as a matter of policy, act as arbitrator, and therefore cannot speak from personal experience on the inner workings of arbitral tribunals. But as a general principle, I would say that BITs are actually not the proper vehicle to deal with other issues of environmental law, labor law, human rights, etc. I find it very difficult to address those issues in the context of an investment agreement, and I don't think that has worked well so far.
Thanks again. Apologies, because I knew that you don't act as an investment arbitrator, and I could have filtered that out. But on the other hand, I think it was best for you to clarify this to our participant. I see no more questions here. You're still welcome to type in questions. We have some 10 to 15 minutes still. In the meantime, since I don't see any questions, I have another one for you, George. I think it's very clear from your presentation, from your responses to the questions, that your ideal situation, your ideal outcome of this reform process is actually to move away from the system and build something new, not build something on top of something that's flawed. I think that's pretty clear. At the same time, states are very concerned that they have these disputes that are being initiated against them. And many of them are not ready yet to terminate their treaties, to move away from this regime for various reasons. Maybe there's not enough political support yet to take that step. Whatever the reasons may be, the cases exist. And this is beyond the concern with the regime and the need to reform the regime more holistically. There is a concern with the cases and how to address them, which is urgent. So maybe one a bit out of the box question here for you would be with respect to the current ICSID amendment, ICSID rule amendment process, which is ongoing. And then just to have, my question would be just to have your sense of what would be one or maybe two or three rules that you would change in the ICSID rules for the benefit of the states. What would you change them? How would you change them?
Well, again, that's a difficult issue. There are, difficult in the sense that there is no radical change that's being proposed. I think there are a number of small, minor rule changes that could be helpful, but nothing that's going to even remotely come remotely close to addressing the core issues. That's my basic problem with the ICSID amendments. But look, there are even small issues that states need to be concerned about. And I'll give you one example. Actually, this is one part of the ICSID rules which is a subject of criticism of ICSID, mainly by the investor community. One of the advantages that the ICSID rules have had over UNCITRAL, for example, is that, and this may seem like a small matter, but it is, from a practical standpoint, actually very important, at least in my experience. One of the most important parts of any case, stages of any case, is the very beginning, the formation of the tribunal. States are almost always caught off guard when a case is brought. Even when they know it's coming, they're not prepared with the defense. They're not prepared with organizing the defense team. And they're, of course, not prepared, usually, with the selection of an arbitrator. At least in the ICSID rules, you have at least 90 days and usually more, just the way the rules work, to make that selection. And frankly, even that is not enough in many cases. Whereas in UNCITRAL and in the ICC, for example, the state has to appoint an arbitrator in 30 days. That leads to very often making the wrong choice, appointing an arbitrator without doing sufficient research as to the track record of that arbitrator, their natural proclivities, leanings, whether they have a strong pro-investor bias or what their reputation is. And when you get off on the wrong foot like that, it's very difficult to recover. So I don't mean to diminish the importance of procedural issues such as that, because they do have an impact. My concern is that they don't address the core of the problem. Now, from a practical standpoint, which is why I have a lot of cases, obviously, this system is not going away anytime soon. And so it is important to pay attention to these details while the process of reform is ongoing.
Thanks for that, George. It's again clear that minor changes to these rules would not be sufficient in addressing the core issues, but it's important that you flag this hurdle in the beginning of the process to select an arbitrator, the importance of this phase for the state. But you also mentioned something in passing that I would like to follow up on before moving to the next question on the Q&A. You mentioned that states are often caught off guard, not prepared with the defense. So beyond the issue of appointing the arbitrator, which you just talked about, what are your tips from the point of view of a practitioner, from as counsel? What would you recommend to states that have these bids and that are subject to these arbitration rules? Obviously, you're not going to give us a complete checklist here, but what are the maybe 2 or 3 key points that you think states should be aware of in preparing for their defense?
Well, I think the first word. Look, I mean, I don't want to give you specific examples right now, but there are a number of cases that I'm aware of right now where states are facing multiple claims and have not even decided which organization within the state is going to be primarily responsible for handling the claim. Going along with this, of course, is the question of how the defense team is going to be selected, what budget the state is going to have for the defense. A lot of people assume that because a state is a state, that it necessarily has a larger budget than the claimant, and then the claimants in these cases, and that almost invariably is not true. If you're dealing with large claimants, such as, let's say, the large oil companies, they have virtually unlimited budgets and they actually spend it on these cases. If you're dealing with claimants that don't have large budgets, now they have a large number of third-party funders out there that are willing to come in and gamble on the case and fund the case. It's usually the state which is at a disadvantage in terms of budget and allocating resources to the case. That is an issue that needs to be faced internally, because as you can see from the proliferation of multi-billion-dollar claims, one loss is too much. The only other tip I would give now is that I think far too little attention is paid to quantum. lawyers in general, not just lawyers for states, but even in the private sector, tend to be more comfortable dealing with issues of jurisdiction and the merits because they're more purely legal issues. But as you can see, quantum has become even more important, overshadowing the legal issues in the case or the issues of jurisdiction and the merits. It's one thing to make a mistake in a $10 million case, and quite another if the case is a $10 billion case. So my advice there would be to make sure that you pay attention to quantum issues, even from the very beginning of a case, in order to know what the exposure is, what the risk is, how to defend it, and whether to perhaps negotiate a settlement.
Thanks again. It's really good to have at least a couple of examples here. You did mention third-party funding briefly, and I would like to dive into that, but unfortunately we don't have time for that. We now have 3 questions here, and I would like to give you the opportunity to reply to one more from Martin Masilela. Do you think the proposed ISDS reforms are applicable even to small economies, for instance, that are at a pressure of attracting investors, especially if natural resources are limited? If you look at countries like Mauritius, for example, is the example that he gave us.
Well, that's interesting. I would have thought that a country like Mauritius, in terms of a recipient of foreign investment, would not need investment treaties. I'm not sure about that as an example of a country that, I'm not sure that any country benefits, because you mentioned before, Martin, the evidence of beneficial foreign investment being attracted by investment treaty is pretty scanty. But speaking of Mauritius in particular, I really don't see why a country like Mauritius would need an investment treaty to attract foreign investment.
Thank you very much. There are 2 additional questions. I'm afraid I'm going to have to wrap up this webinar, though I do want to acknowledge those questions for a later discussion. So I'll just read them out loud and leave them hanging over our heads for us to reflect. So one question from Oladapo Fabusui again. He shares George's views that a BIT is not the appropriate instrument for addressing environmental laws, labor laws, human rights, but shouldn't they be retained at least to tilt the balance in the interest of both states, since ISDS still has influence? And another question is with respect to the new Chinese foreign investment law with provisions that are akin to bid protection, such as expropriation. And this is from an anonymous attendee. He or she asks whether domestic investment law, such as this Chinese law, with foreign investment protection elements, could become an alternative to BITs as a reform solution to the current system. So, George, I would like to wrap up, but would also like to give you 1 minute to maybe address either or both of these questions.
Well, I think taking the second one, there are many countries that have foreign investment laws. And this is a long discussion. I will just point out that the problem with foreign investment laws from the investor's standpoint is that they can always be amended and revoked, whereas the investment treaties are not as easy to terminate because they have these long tails on them. But that's a much longer discussion.
Thank you very much, and hopefully we can follow up on these discussions. So thank you again first to you, George, our expert speaker today, for sharing your thoughts with us at the forum, and as well as for kindly accepting our invitation to be here today to answer questions live. Thank you as well to all of our participants today for joining and participating actively with questions. I'd like to thank also my ISD colleagues, Joe Zhang and Sofia Balinho in the Geneva office, who have helped us prepare for this webinar. This video will be available on ISD's YouTube channel as well as on our website. You have the link to the project page of our webinars. We will make it available in the next week or so after a few edits. We will let you know if you are here attending now, you will receive an email notification that the webinar is also available for viewing. Thank you very much and have a good rest of your day wherever you are.